Hey everyone, welcome back to my channel. So today I will be dealing with one of the important topics, that is golden triangle. As we all know, golden triangle, like the term triangle mean, it talks about the interconnectedness between three important articles in our constitution. Those articles are Article 14, Article 19 and Article 21. As we all know, Article 14 deals with right to equality and equal protection of laws. Article 19 deals with right to freedoms and Article 21 deals with right to life and personal liberty. So what is Golden Triangle? Golden Triangle means talking about the interconnectedness between these three articles, that is Article 14, 19 and 21. So this interconnectedness can be either the mutual exclusiveness or mutual inclusiveness. Mutual exclusiveness means these three articles are completely distinct. Then mutual inclusiveness means these three articles are interconnected or there is some relation between them. Or when one is violated, automatically the other will also be deemed as violated. Now coming to the evolution of Golden Triangle. As far as the evolution of the Golden Triangle is concerned, the judicial pronouncements are very important because this concept has evolved through judicial pronouncements, especially from the case of A.K. Gopalan versus State of Madras till case Puttaswamy versus Union of India. The courts interpreted this concept, that is, the interconnectedness of various fundamental rights in the Constitution. And in the earlier time, they were of the opinion that various fundamental rights in the Indian Constitution are mutually exclusive. Then they have adopted a view that various fundamental rights are not mutually exclusive but mutually inclusive. So this way, through the judicial pronouncements from the concept of mutual exclusiveness, they have shifted their view towards the concept of mutual inclusiveness. And this concept, that is Golden Triangle, that is very much connected with the mutual inclusiveness of the fundamental rights. Because Golden Triangle says that three articles are interconnected, Article 14, 19 and 21. So that means interconnectedness of these fundamental rights. That shows the mutual inclusiveness of the fundamental rights. One of the important case with regard to the concept of Golden Triangle is A.K. Gopalan versus State of Madras. In this particular case, that is A.K. Gopalan versus State of Madras, A.K. Gopalan was detained under the Preventive Detention Act. As per Section 14 of the Preventive Detention Act, disclosure of the grounds of arrest is prevented even in the court of law. That means when a person is being arrested under the provisions of the Preventive Detention Act, then the grounds of arrest need not be informed to the person who was arrested, or it need not be disclosed even in the court of law. Therefore, A.K. Gopalan was not informed with the grounds of his arrest. Then he filed this case before the court and he claimed that Article 14, 19 and 21 was violated. The majority of the judges in this particular case was of the opinion that each of the fundamental right deals with distinct matters. When requirements of one particular article are met with, then no violation can be conferred on it on the violation of other article. For example, the requirements of Article 14 are complied with, then it cannot be deemed as violated on the violation of other fundamental rights like 19 or 21. So that was the opinion of the majority of the judges. And they considered the relationship between articles like Article 19 and Article 21. So while comparing, they have held that Article 19 is dealing with not all elements of personal liberty. But on the other hand, Article 21 is dealing with personal liberty in a wider sense. So there is that difference. And also 19 is applicable only to the citizens. But 21, Article 21, that is applicable to all the persons. So there is also difference. And moreover, what is following under Article 21 is the procedure established by law and no due process of law. So these kinds of differences are there. Therefore, we cannot interconnect these two articles, Article 19 and 21. So the majority of the judges was of the opinion that these two articles, Article 19 and Article 21, are distinct from each other. Therefore, we cannot say that they are mutually inclusive. Rather, they are mutually exclusive. So that was the opinion of majority of the judges in that particular case. And in the dissent, Justice Faisal Ali was of the opinion that there are certain overlap between the fundamental rights. That means when we widen the scope of Article 2, that is the definition of state, when it is widened, it will have an impact on the other articles like Article 19, Article 14, Article 21, etc. Because all these fundamental rights are available against the state. So when the scope of state is widened, then it will have an impact on these articles also. So that was the opinion of Justice Faisal Ali. He said that there is some kind of overlap between these fundamental rights. Therefore, it cannot be said as these fundamental rights are completely exclusive of each other. So that is the case A.K. Gopalan versus State of Madras. The majority of the judges was of the opinion that fundamental rights are mutually exclusive. But in the minority judgment, Justice Faisal Ali, he held that there are certain overlap between the fundamental rights. Another one important case with regard to the concept of mutual exclusiveness of the fundamental right, that is Kati Rani Rawat versus State of Saurashtra, and there are some other cases like Kar Singh versus State of Uttar Pradesh. All these cases established the mutual exclusiveness of the fundamental rights. Then coming to R.C. Cooper versus Union of India. For the first time, the mutual inclusiveness of the fundamental rights was held in this particular case. In R.C. Cooper versus Union of India, the interconnectedness of two articles were discussed, that is Article 19 and Article 31. Both articles provide some restrictions, especially under Article 19 Clause 1 Clause F, that is right to property. At that time, there was restriction under 19 Clause 5, and also Article 31 provided certain restrictions, especially under Article 31 Clause 1 and 31 Clause 2. So this way, both these articles are in a single pattern. So the court held that these articles are not mutually exclusive. So these both these articles, Article 19 and Article 31, were imposing some kind of restrictions on the right to property. So 19 Clause 5 put a restriction on the right to property of the citizens, and on the other hand, Article 31 Clause 1 and 31 Clause 2 is a kind of restriction on the government, from taking away the property of the private individuals. So in that way, both articles are somehow interconnected with each other. So that was the decision. And in that case, for the first time, the mutual inclusiveness of the fundamental rights were established by the court. This concept of mutual inclusiveness of the fundamental rights was established through the series of cases like Shambhunath Sarkar versus State of West Bengal, Haradan Saha and another versus State of West Bengal, etc. And in the case of Maneka Gandhi versus Union of India, for the first time, the interconnectedness between Article 14, 19 and 21 was discussed. And here, the court interconnected these three articles by saying that suppose when we consider two articles, Article 14 and 19, Article 14, that is equality and equal protection of laws, that is against the concept of arbitrariness. And under 19, there are some reasonable restrictions. That is, those restrictions must be reasonable. There should not be any element of arbitrariness. So in these two articles, there is absence of arbitrariness. Therefore, these two articles are interconnected. Then when we take Article 21, there is procedure established by law, and that procedure should not be arbitrary. So again, there also the absence of arbitrariness is coming into picture. Therefore, these three articles are some way interconnected. And also, when we take into consideration two articles, Article 19 and Article 21, Article 19 guarantees various freedoms like freedom of movement, then freedom of assembly, freedom of association, etc. And Article 21 says that life means not mere animal existence. So, in order to lead a dignified life, we need to have the right to movement, right to assembly, right to association. So, a lot of other rights must be there in order to enjoy this right, that's right to life and personal liberty. So, in some way, these two rights, so Article 21 and Article 19 are interconnected. Therefore, when we are not having the right to freedom of movement, which is guaranteed under Article 19, Clause 1, Clause D, how can we say that we are actually exercising the right to life under Article 21? Because when we are not having the freedom of movement, we cannot enjoy our life. That is not life. Life is not mere animal existence. It is something beyond that. So in order to in order to experience that life which is beyond the mere animal existence, we need the right to freedom of movement, right to speech, right to assembly, right to freedom of expression. So all those rights must be accompanying the right to life. Therefore, we can say that Article 21 and Article 19 are interconnected. Another one important fact is that in order to live a dignified life, which is guaranteed under Article 21, that is right to live with dignity, we need all these freedoms. We need all these freedoms like freedom of speech and expression, freedom of movement, because only then we can live a dignified life. Therefore, Article 21 and Article 19 are mutually interconnected, mutually inclusive. So there is interconnectedness between them. And that way, in Maneka Gandhi versus Union of India, for the first time, the interconnectedness of these three articles, Article 14, Article 19, and Article 21, was established. In that way, after Maneka Gandhi versus Union of India, through the case of Minerva Mills Limited versus Union of India, Bachchan Singh versus State of Punjab, I.R. Coelho versus State of Tamil Nadu, Justice K.S. Puttaswamy versus Union of India. In all these cases, the concept of mutual inclusiveness of the fundamental rights and the Golden Triangle theory was upheld by the court. This is how the concept of Golden Triangle has evolved through the judicial pronouncements. As a conclusion, I would like to explain the concept of Golden Triangle once more. Golden Triangle means interconnectedness or mutual inclusiveness of these three fundamental rights, that is Article 14, Article 19, and Article 21. So, as per this concept, when one article is violated, then the other articles will also be deemed as violated. That is, when Article 14 is violated, then Article 21 and Article 19 will also be deemed as violated. So that is the concept of Golden Triangle. I'm getting little sleepy. Actually, forgot to mention one important question in this particular area. That is with regard to the mutual inclusiveness of various fundamental rights. In my opinion, there is a big issue, because when we say like various fundamental rights are mutually inclusive, there arises a question as to their individual existence. Because the violation of one particular provision or one particular article will automatically result in the violation of other articles, then is there a need for individual existence? Or all these rights can be combined into one particular provision or one particular article? So that's the question. You just look into those area. Thank you.